in WA 298 of 2022, my lord.
What is the urgency?
The urgency is that it is with respect to building permission, my lord. There is a threat of demolition in the matter. There is a threat of demolition.
Review what has been held. Your petition has been dismissed.
Yes, my lord. What has happened is my right.
When did you file the review?
Review was filed, my lord, last week.
Last week it has not come up.
No.
Why? The rule is that the moment it is filed next day it should come up. That means office objections.
No, my lord. It is numbered also. IA has been numbered.
Then why it is not listed?
Which may directed to be listed at any.
1710.
Your Lordships, kindly minutes. Let's wait to the Lordships in this matter pertaining to not extending the reservation under sports quota MBBS and BDS courses, Millets. My lords already heard this matter on last week of August, Millets, and the matter is Millets. Last phase of the counseling is carried out, Millets, in the university, Millets. Is a very threat of Millets. Is a matter is covered by the orders also, Millets.
Covered? What do you want? Final hearing? That doesn't happen through memo. File an application for early hearing.
The present writ petitioner is challenging the non-local status given to him in the ongoing PG medical counseling, my lordship. We have challenged it through that petition and it's supposed to be listed on 4th week of September. The urgency in this matter is, my lordship, the third phase of counseling is currently going on. So expeditious disposal of the writ petition is
Expeditious. You want final hearing?
Yes, they
Then
already
we
filed.
know an application for early hearing. This is not, we don't repeatedly, every day we have to tell all of you. I mean, that means the message is not being this thing, that we don't fix dates for final hearing through mention memo. Yes,
May I be
please
permitted?
remove an application.
May I be permitted to move a lunch motion, my lord? Two matters, medical admission matters. The petitioners were given a seat in the second round of counseling.
Third gender status.
My lord, it's a different matter. They were given a seat in the second round of counseling.
They have all the cases of third gender status, so we thought that
No,
again
it's
third
a different
gender
matter,
status.
different subject matter rule. They were given a seat in the second round of counseling. The hospital failed to upload the joining letter on the MCC portal, due to which their seats were allotted to different candidates in the third round of counseling. Now we have communications from those candidates also that they don't want
Who
those seats.
appears, I mean,
Central government, my lords.
no,
MCC
they
is the
should
central government.
supply them a copy and ensure we take it up tomorrow then.
Your lordships may have it today because tomorrow is the last day and those seats will be allotted in the stray round next. And today is
When is the stray round?
tomorrow. I mean, tomorrow is the last joining date for the third counseling.
No, stray round, I mean, they will be allotted in stray round, right?
Monday.
So we can take it up tomorrow, right?
There is an urgency, my lord.
No urgency.
Let them get it. Let your lordships may have it today.
They should-
Let them get instructions meanwhile.
Instruction what? You have not supplied them a copy. They don't know anything. He will stand like this and seek time. What is the use? Let him have. You supply him and let him. He will. You find out, Mr. Praveen Kumar. We'll take it up tomorrow.
There's also a private respondent, my lord. Your lordship may permit me to give them the intimation of this date for tomorrow in advance, so that due to paucity of time we might.
We don't know of a procedure of this where admission. Who will decide? Private respondent will
No,
decide
private
that
respondent
whether
is
you
the
should be
hospital.
admitted in
No,
the
private
this
respondent is the
petition.
hospital.
You give him supply, take him, give him copy and get an order from him. Why to come to the court? This is a procedure which is not known, madam. At least I have not
I
known.
apologize.
I mean that before filing of the petition, it's your choice. There will be no order of the court.
No, your
Because
lordship.
whatever we say, you say that the court directed me to do this. Court directed. You are putting words in our mouth, and then you will say that the court directed to do us
It's not my-
to serve respondent number 2. I am not aware of any such procedure. You please tell us where is the provision in the rules that
Your lordships may
before
have
this thing petition is it should be served on Friday. It's your choice. We will not direct anything. It's your choice to serve.
Your lordship may have.
Yes,
My lords, this is pertaining to the police recruitment.
tomorrow.
The yesterday results was announced. My lord. Actually, this honorable
Results were announced.
announced that the police constables. My lord. Actually, the
What do you want? Final hearing, all of you.
my lord,
Final hearing.
early date.
Early hearing. So it will come up for orders on early hearing. It will come up on a day. We will fix a date on that.
Yes.
Not like this that we can't hear just because the result has
So,
come.
my lords, the problem is, my lord, they
No
also
problem.
this honorable
17th October for early hearing. Yes.
Your lordship.
Orders on early hearing. We will decide on that day which day to be heard. Yes.
Your lords. mention against administrative side. Submission, my lord. Actually, they issued this honorable court. They won't.
What, I mean, you want that right now it should be allowed along with copy and they should be sent to jail for forever remaining part.
Any date next week would be Saudi purpose.
We have given a date. We have given a date for early hearing. Yes.
It's a mention.
Whatever date was mentioned.
Is a mention your lordship.
No mention. What it will be called? Case will be
Your
called.
lordship, this is mentioned regarding the administrative side. Your lordship, this is a matter pertaining to serious.
Administrative side?
Your lordship, this is a matter pertaining to your fear.
No, you have to, Mr. Administrative side mention cannot be made in a division bench. You talk to Registrar Judicial
Of
meeting.
course, from last 1.5 months, your lordship, I am approached and given a letter also, your lordship, the matters are not being listed. The matter pertains to year of 2005 to 22. At any bench, these matters are not being listed, your lordship.
You approach him, he will look into it. This is not the forum, Mr. Making a complaint before division bench, most inappropriate. And we thought that you are a sensible person who knows. This is most inappropriate thing that you tell us why we should not penalize you for this. You should have given, written a letter, like I mean, address, communication.
I have written a letter.
This is not way. This is, you are insulting his lordship. This is a division bench. Can you mention a matter in respect of which I have to take a decision before a division bench? This is not proper. Yes.
My lord's application.
You meet him, it will be, action will be taken today. This is a unique way, right? Mention and then get instructions. This is not fair, Mr.
Last 1.5.
Not fair, not fair. We repeatedly telling you not fair. Not fair on your part. This conduct matters. Cases come and go, but conduct and your stature as an advocate matters. You have told by your conduct something about yourself. We will remember that. Yes.
So I beg to make a mention, my lords. I beg to make a mention.
Your lordship, for this.
No, this is unfair.
Your lordship,
Unfair.
3 times
Yes.
you have-
For fixing an early.
No. So therefore, you with 3 times you have approached. There is no other means of this thing. No other means of sorting out a problem except to make a mention before division bench and make a complaint against Registrar Judicial. Orally, this is what you are doing. Unfortunate. Unfortunate. Any youngster would have done it, we would have understood. We thought that you are a sensible lawyer and you understand. Unfortunate. Yes.
Application seeking fixing of an early date.
12:10. Yes, next. Huh? 17. All cases to your liking cannot be heard because client is pestering you, right? You come at in this thing when the motion cases are over and 2005 writ appeals are taken. Yesterday we have delivered judgment in a PIL of 97-98 remanded by Supreme Court in the year 2006. You tell us what is the fault of a person waiting patiently for 18 years and there the lawyers seek adjournment. Here you just want because you have not been granted interim relief, so I should get the interim because client is sitting on your head. He is telling that you are unable to get it listed, so you are pestering all 2023. So it should be the reverse order. Like the concept should be the one who files the petition for later should be decided first. So like we should evolve a system and try to do it according to you. That if you have filed a petition today, the endeavor should be in 48 hours, it should be disposed of. This should be the endeavor. This is what it is.
Actually, there was a.
Yes. I think enough. Yes. Yes. So correct order. There is no need for, we only can say that this issue shall be decided without being influenced by the order after framing of the issues on merits by the commercial.
Trial has started. The problem here is after the trial, framing of
So
issues.
you want an order on merits, we will pass. No problem.
Only in our lordship mein
Nothing.
1 minute, my lords.
Yes, go ahead. Please, you have a right to ask me.
The trial has started.
We have read it, Ms. The 5, you tell us why, how any issue with regard to non-joinder of necessary parties, a plaint can be dismissed. The suit is for declaration. The plaintiff has dominus litis. Plaintiff decides against whom he wants to contest. How can you say that such person has not been implemented, therefore the suit is
not.
barred by law.
I'm not asking impletion, my lord. There is a problem. The case is, my lords, I am a supplier of a machinery. Dependents to 3, 4, 5 has 3, 4 has to pay me the money for the machinery and I have to supply the machinery. After framing of issues, he withdraws against dependents 3 and 4. His main prayer 1 is that
Suit will be dismissed if non-joinder of necessary parties. Why should you worry?
he has withdrawn after trial started, my lord. That's what the point is. After trial starts, in the chief examination, he only goes for.
He will not get any relief. You should feel happy.
He's asking.
If I would have been in your position, we would have advised the client to wait quietly and wait for dismissal of the suit.
Yes, but I agree, my lord. But the problem is, he is asking damages on me, not paying the money.
He can ask anything against you. But no law can prevent filing of a suit even if it is frivolous. You don't have any immunity from legal proceeding. Under which provision of law? That no suit can be filed against you.
That suit is, that's what the doubt is, my lord, because he says he has withdrawn against 2 and 3 minor financials.
Sorry.
And he has amended this, without amending the suit, he has withdrawn. And
Anything else? Yes, heard. This heard on the question of admission in this petition under Article 227 of the Constitution of India.
Appellant is a state government and a central government owned colliery.
Huh?
with my lords, coal mines and power production units across the state. The first respondent trade union, which is one of 15 trade unions in the appellate, filed the writ, my lords, out of which the interim order is impugned before your lordships. The writ, my lords, merely sought a direction to conduct the elections, my lords, to have a recognized union. Before it,
That was done previously also.
my lords, there was a direction issued and time was extended on account of the fact, not that the upcoming state elections were to be held. May I just take your lordships to the previous order before going to the impugned order? Page 42, my lords.
No, see, Mr. If despite previous directions, if elections were not held,
Lordships.
what is your remedy to file another application?
We sought for extension of time.
Ah.
The impugned order before your lordships rejects our application for extension of time to hold the election soon after the state elections. And the reason is the state machinery, my lords, is involved in the conduct of this election. There are 6 districts and 43,000, my lords, voters by secret ballot, and more than 700 officers of the state are involved in this election. And in fact, that was the ground on which the earlier extension was.
Who has to hold elections?
But the election is conducted by the 6th respondent. That is the.
All right, you supply a copy to 6 respondent, then we will see. Are you appearing? Are you appearing? 6th respondent?
6th respondent, lordship.
Are you appearing?
Yes. Whose election has to be conducted by the 4th respondent. I'm so sorry. The RO, my lords, the RO is the DCLC, the Deputy Chief Labour Commissioner.
Yes, Mr. What do you say?
Earlier,
See, Mr. Despite directions, right, of the court, and despite extension of time, if the elections have not been conducted, for your inaction, why? What you tell us? You seek instructions on this and come up with a statement within how much time will you? Because elections are required to be held, right? You seek instructions.
Page number 52, page number 54.
54.
Page number 54, there is a direction from the Salport, IA 3 of 2023. The operator portion,
No, whatever, Mr. This is only against an order. He was seeking extension of time. So, presumably, as we can make out that due to whatever XYZ reason, maybe unavoidable reasons, you have not been able to hold the elections.
we are ready, we have to comply with the directions of the Criminal Court made in IA number 3 of 2023. Schedule has been done. Schedule has been done. They are not cooperating. Neither the management will.
They have.
Not the government. It's not cooperating.
I didn't make this aspect clear. Page 54.
54. Yes.
An earlier order passed by the learned single judge.
Yes.
Took into account the fact, my lords, that the Telangana State Legislative Assembly is upcoming. Page 54 at 56, my lords.
Yes.
The third line. Learned additional AG has further submitted that on such requisition by the RO, several district collectors have expressed their inability to adhere to the election schedule proposed by the RO, citing several reasons. Inter alia, it was stated that enumeration of voters for the general elections to the assembly to be held in 2023 has commenced, and the entire state machinery and officers of several departments are being trained for ensuing general elections, and their services are being drafted for election duties. And some of the DCs have also stated that special arrangements need to be made, as some areas of Singareni collieries come within the areas having influence of Maoist extremists, and requested this court to defer the election process to be commenced from 1/2023, so that the process relating to the upcoming general elections in the Telangana State Assembly could be completed. This was accepted by the learned single judge, my lords, in this last penultimate paragraph, holding that since, my lords, this is the circumstance, the extension is granted, my lords, till October. In the interim, my lords, the Election Commission of India has notified, my lords, the schedule for the state elections to be held. Now that at page 472 stipulates 7/12/2023 as the tentative date, my lords, for elections to be held. Accordingly, on the same circumstances in which the earlier extension was granted, we went back to the learned single judge, as also, my lords, the state government, saying, since all the officers are now, my lords, required to be involved in the state elections, kindly defer it by a further period, my lords, of maybe a month or so after the state elections. That has been rejected by the learned single judge. And this election, my lords, 13 out of the 15 trade unions have also written, my lords, to the respondents saying, please defer it after the election.
Lord, with due respect,
So therefore,
it is not like that. Lord, all of the, Lord, may kindly see the minutes of the meeting.
We are only issuing notice, you seek instruction. We will hear.
Very
the second
Mr.
respondent may not, my lords, the writ petitioner may not precipitate matters in the meanwhile.
What, he will seek instructions, it will come up after a week or so.
very good. Logics.
Mr. Aditya Sondi, learned senior counsel, so and so.
Please, Your Lordship. I appear for the writ petitioner in this matter.
Yes.
My lord, at the outset, my lord, I apologize for bringing up
No,
the
no.
petition before.
Yes, his application is pending, seeking.
No application is pending, my lord. There is no.
No application is pending, Mr.
My lord, appeal is filed before the appellate authority. It is pending.
Appeal.
Appeal is pending, appellate authority is not at functioning, my lord. Appeal for the, but their prayer is not, application
No,
is
no, Mr. But see what is this thing, a prayer, which you go by what you have said in the petition.
My lord, I would
Not
make
passing any order on the application submitted by CFE, CFO, illegal powers, canons of justice. And they are saying that there is no application pending.
my lord, I would make this submission. My lord.
Ah.
In fact, my lord, the more of a grievance of the writ petition as it appears for me is the non-constitution of the appellate authority under the Water and Air Acts. My lord, the term of office expired on 4/8/2023.
Mr. Council, then the prayer should be like that, right?
No, no,
Ah.
it should have been like that, but
Ah.
I would only
So you amend the prayer, then we will of course deal with it.
I am only submitting for your lordship's consideration that
Huh?
there was an
No, but
earlier.
this is not a PIL, nothing so moto. What is why which?
I quite.
But this is you are only saying that your application is pending, that is not decided. They are saying that the no application is pending. So tell us which date you submitted an application. Where is it?
Those applications I shall place it before this honorable court, my lord, because I didn't want to bring down the constitutional court's functioning to the consideration of an appellate authority.
No, but this is, Mr. Please see, I mean, then you make a prayer like this. We are dealing with the prayer and then you are saying constitution. We don't like. But you file such petitions. Yes. See the prayer clause. You are appearing, you have to take responsibility. I mean, what is the prayer? What? The court should not go by prayer clause.
True. No, I am not for a minute.
What?
Prayer may,
What is this? You have made a prayer. They will adjudicate this. They have taken a stand, no application is pending. If it is found that no application, we will impose cost on you.
My lord, I'll,
Misleading the court and wasting the time of the court.
may I make one
Yes.
submission? I'll ask the writ petitioner to withdraw the writ petition, my lord, with the liberty to file.
Learned counsel, senior counsel for the petitioner, after arguing the matter to some extent, see. Accordingly, the writ petition is dismissed as withdrawn with liberty as aforesaid. Next.
Lord, sir,
So where is the order you have filed? Not filed.
I filed an memo. Two of the directions I've already complied with. One
No,
is,
22nd September you have not complied with, Mr. Order sheet of the proceeding date on which you, Mr. This is not, I mean, this is not, you, the order was passed in your presence. If you don't know, it is, we are not sitting here to tell you what is the order passed and this thing. If you don't want to comply, order dated 22/9, you want time or you, this thing don't want to comply.
Lordship, I've already applied for it. I'm awaiting that because the,
How much time do you want?
after 1 week, it may be.
Party in-person praise warrant is granted 2 weeks further time to enable him to comply with the directions contained in the order date. Yes.
Item 5, my lord. The application for appointment of an arbitrator being contested on two grounds, my lord. One is that the applicant himself submitted to the jurisdiction of civil court. He has waived his right and-
They see these petitions are pending since 2017, right?
Yes, yes.
You are not in a hurry.
I'm for the respondent number 1 in the matter.
Not in a hurry. It will come up before me on Friday.
Yes.
Tomorrow. Let the
Instead of Friday, can I make a request, my lord?
No.
Monday,
No. Not Monday. I have to sit single, right? Let.
next Friday.
No, this tomorrow.
Oh, public.
2017, Mr. The institutions point at us saying that the High Court is unable to decide the arbitration applications. Please cooperate at least in these cases.
Yes.
Please, this is a blot on us. Please cooperate.
Yes.
Any other case you can seek next week, after 2 weeks, I am going to US, whatever. Please do, we will not adjourn in this case. Even if you don't appear, tomorrow it will be decided. This is my promise to you.
Yes.
Yes.
I beg
Don't
pardon, my
appear.
lord. I am representing applicant, my lord.
Let arbitration application, let the same be listed tomorrow.
My lord, I beg
For a single bench, in single bench.
in this matter,
Ah.
I beg to withdraw this application, my lord.
Acha, you want to withdraw?
Okay, my lord.
Learned counsel for the petitioner, this petition under section 11 within bracket 6 of the Arbitration Conciliation Act has been filed seeking appointment of an arbitrator to adjudicate the dispute between the parties. Learned counsel for the petitioner submits that the petitioner does not want to prosecute the petition. The same is accordingly dismissed. Does not want to press so and so, therefore seeks leave of this court to withdraw the same. The aforesaid submission is placed on record. Accordingly, the petition is dismissed as withdrawn. Next.
Next, my lord, the item.
Next, does it survive now? Next.
Yes, ma'am. It has to, here, since the applicant has withdrawn the first matter, my lord,
Nothing.
CRP has to be allowed, my lord, because the application before the trial court was for appointment of an arbitrator. It was allowed, against which I filed the revision, my lord.
Yes,
It has to be heard on merits, my lord. CRP has to be heard on merits.
How on merits? Argue. This is CRP.
CRP is the petition. He is for the petition.
Yes, go ahead. What is?
Wait, my lord, the revision is preferred against allowing of an application for appointment of an arbitrator, my lord. When the,
No, Mister, you don't want a appointment of an arbitrator, right?
Yes, my lord.
You have withdrawn that. Now what survives in this
My lord, when the
CRP?
commercial trial court has already referred the matter to referring both the parties for arbitration, this arbitration application was not maintainable. This arbitration application was instituted because the arbitration notice was sent prior to this order under revision. Therefore, I am withdrawing this arbitration application. So far as the order, impugned order covered by this provision is concerned, my lord.
What is, yes, yes, what is the agreement dated, Mr.? Agreement is date of agreement between the parties?
It is, my lord, 27/7/2005.
Where is which page?
This page 40, no, in this matter, it's not filed, my lord. The earlier matter is
It is filed, my lord, page number 25, my lord. 25 is the arbitration clause.
page 40 of the metal papers.
20? See, madam.
26 partnership deed.
Arbitration clauses?
Yes, my lord. Arbitration clause number 25, my lord.
25. Yes.
That any of the above terms and clauses may be altered, modified, cancelled.
Clause 25.
Clause 24, my lord. Pardon.
No, we didn't get the page. Which page? Which page, Mr. of this,
According to my
this CRP, which page?
According to the metal paper available to me, it is page number 26, madam.
26.
The partnership deed dated 17/7/2005, which was marked as Exhibit A4 before the trial court.
There is no, it's not filed. It's not here in this this paper book. Other one, other arbitration thing.
At page 40, clause 18.
Partnership deed 17/6/2005.
Yes, madam.
It is page 34 in the other paper book, Mr.
It clause of 24 of this partnership deed, the page number 8 of this document, the arbitration clause is there.
Which clause? 18 is the arbitration clause.
Yes, one. 18 is the arbitration.
So then what if agreement contains an arbitration clause? The court has to refer them to arbitration. What is wrong with the order?
My lord, prior to this, there's the applicants, there's the respondents in the CRP, my lord, submitted themselves to the jurisdiction of a civil court, waiving their right under clause 18 of this deed. They have filed a suit. Admittedly, they have filed a suit. My lord, OS 1201 of 2016. Same applicant.
Mr. What does the clause, what does section 8 of this thing agreement?
Yes. Section 8.
You have filed a suit for rendition of accounts, right?
Dissolution of the partnership firm. Rendition.
You have filed a suit for rendition of accounts and dissolution of partnership firm.
Yes.
And in that suit, the respondent in the petition made an application under section 8.
Yes.
The court has allowed.
Yes.
What is wrong with it?
Against, my lords, two grounds have been raised by me. Challenging the allowing of application under 8.
What ground?
First ground is that the partnership firm had already filed a suit OS 1201 of 2016. Partnership firm, the applicants before lordship in the other matter, they have already filed a suit. Submitted
The respondent has filed a suit.
OS 1201 of 2016. 1201 of 2016. Against because there were disputes among the partners, the firm filed a suit against the revisional petitioner before lordship for recovery of money based on the dispute.
No. So what I mean, respondent has filed a suit. Then
OS filed a suit. Thereby giving up their right under clause 18 of the partnership deed to refer the matter to arbitration. They submitted themselves to jurisdiction of a civil court.
Parties can give up the right like
They
this.
can give up the right because they opted out of the arbitration agreement, filed a civil suit.
What happened to their civil suit?
As on that date was pending, my lord. Thereafter, no instruction. What happened? Some other.
No, so you tell us how it can be like.
Because the suit was filed by partnership.
No. So the challenge to the ground, as we have understood, is that since the respondent himself has filed a suit, therefore he could not have filed an application under section 8.
Yes. Yes.
Any authority for the proposition, like.
In fact, my lord, I couldn't bring the short of time.
No time is. This is
In
what.
fact, I was relying on Rashtriya Ispat Nigam Limited 2006-7 SEC.
Huh? 2000?
2006-7 SEC 275.
Huh?
Rashtriya Ispat Nigam Limited, my lord.
Ah.
There they said that while going through whether the parties are given up their right to refer the matter to arbitration or not, my lord, they also said that a clause, a mere filing of counter in interlocutory proceeding would not be a bar to refer the matter to arbitration, but the moment they take a step of filing the detailed statement of dispute, they are prohibited from invoking the arbitration clause.
The petitioner has not filed the pleadings in that suit, my lord. Nowhere in the pleadings in that suit, it was mentioned that the parties have gave up the arbitration clause.
Yeah, they
Mr. Best remedies to file review of this order on whatever grounds. If those grounds were not addressed before the court passing the order, you cannot be permitted to assert.
It is done, my lord, was given in detail in the counter.
But where have you argued? Show us
Yes,
from the
Lord.
order.
Yes.
Order that you have taken note of that he
Yes,
has
High
given
Court
up.
has totally ignored these contentions of the
Which
petitioner, my
then
lord.
ignored means then your remedies to file review.
My lord, can my lords may kindly take up page 52 of my material.
No,
paper, my
no.
lord.
This order. Tell where have you raised this contention?
Yes, exactly. That's what my submission is, my
Yes.
lord. My lord, page 52 of the material papers, my lord, revision.
No, this order is 16th February 2018, right?
Yes, my lord.
Where is which paragraph you have argued that this is given up and all this?
That was not observed by the trial court at all, my lord. But
So then file review, Mr. If a
in
contention
fact,
was
my
raised.
counter contained in detail the manipulation of accounts.
You then,
misappropriation.
if you see, we will not permit the order to be assailed on new grounds, which was not.
No, we are not raised any new grounds, my lord. All these contentions are raised.
If the grounds raised and not considered, that is why we review.
I understand, my lord, but
Yes. That's why. We will grant you the
liberty to file.
Yes. Mark the presence this petition.
It's my request for a pathway.
Huh?
For the respondent.
Well, item 7, no?
Yes.
What?
Lord, item 7, I appear, my lord, lordship. Lord, I am the appellant in item 7.
I'm for one.
This is an after notice matter.
Yes, my lord, it's after notice. The matter was supposed to be, listed in June 23 for disposal. My lord, that's why we made a
Disposal?
mention.
No, where is the?
In the sense, my lord, it's a short question of, my lord, the.
And that we will hear some other day, not today, some other day. Mr. Senior Counsel, we will hear it some other day.
Also may consider some short date, my lord.
19th,
Short date, lordship.
19th October, 19th. Let the petition be listed for final disposal. No, but you will have to do some homework, right? Give a synopsis and this thing.
I have already
You are
given.
brief.
It is before.
These are facts in one page and your submissions on the next page. That's all.
My lord, I have
It's
already
not point.
submitted
It
the
should
documents,
not.
my lord. It is there before Lordships.
taking into account the nature of
19th
controversy involved. For early date,
No, it's writ appeals are fresh writ appeals. Additional Solicitor of India is.
They make to appear not for the,
yes, yes. What?
make to appear for the appellants brought in the writ appeals.
No, there are so many IAs. So what is 3 IAs? Dispense with suspension petition and fix an early date. Who has filed early date?
We have filed.
We had filed blood for moving the appeals blood. The
All right.
application was filed.
At the presence heard on IA number 3 of 2023, no orders are required to be passed on IA 3 of
Provisional attachment which was passed has been set aside on the ground that the adjudicating authority blood was presided over by a single member, and that single member blood was not a law graduate or a person blood with training in law, and therefore blood it was not a proper jurisdiction blood is the finding of the honorable single judge. But, the attack was that there should not be a single member to hear the matter. If at all it is a single member who is hearing the matter, he should be a person who is trained in law. Now, 4 questions plot were framed for consideration plot by the honorable judge. Lords will kindly get it plot at page.
No, so appeal has already been entertained, right? Not yet.
The writ appeal is coming for admission before your lordship.
Admission, all right, yes.
I'm sorry for intervention. Now what's happening, Milord, there are some writ petitions filed on the same point. They are also listed. That is Milord, item number 11, 13 and 14. The same point is involved where we file the writ petitions directly before the division will generate the writ petitions. Now writ appeal is also there. Now Milord, these writ petitions are listed for the first time. On the earlier date of these were not listed. Any date will be ready to proceed with the case. Any date because they are interconnected. Because the point in the writ petitions and the point in the writ appeal are one of the same. The other single judge has taken 2 views. One is that without a judicial member, the bench cannot be constituted. Second point is that 180 days is concerned.
His submission probably submission of ASDI may be that there is no such requirement in law.
Yes.
Which has been read into the provisions. Like Mr. ASCI, these respondents, counsel for respondents are willing to argue the matter.
But I am ready to argue.
And some in this bunch, some fresh petitions are listed. So, like completing the process, we will have to formally issue notice and all that. So,
in the writ petitions, we have filed our counters and pleadings are complete. So far, the writ petitions are there.
So, tell us an agreed date when we can hear this.
Lordship may fix any date, subject to your lordship's convenience. On 16th or 17th of October, if your lordship so pleases.
16th of October, what do you say? Yes, Mr. Srinivas.
Yes.
16th of October.
In the meanwhile, I would humbly pray, lordship may suspend the operation of the order of the honorable single judge. There is a direction that we have to release the properties which are the subject matter of attachment, and this judgment is being cited before other honorable courts in Hyderabad and also in other states, saying that an order which is passed by a single member is quorum non juris, and therefore on that ground attachment orders which are passed properly are now we are not able to give effect to it, and we are losing the security which is there, which we are entitled to have.
No, we will say that the observations made shall be confined to the case of respondents only and shall have no bearing in other cases.
And in the meanwhile,
but we will clarify so that it is confined and we hear it on 16th.
Yes, but and the lordship may also, my lord, status quo will be maintained with regard to the attachments which are already made.
All right, the status quo we maintain. Till 16th, Mr. Till 16th. One
13.3, the rate petitions were allowed by the learned single judge. By following,
status quo, whatever.
I tell it there. Following Madras Bar Association judgment, where yes, the judicial member a tribunal cannot be constituted, nor that the future proceedings can be. Now, let my lords may kindly say 21.9. My lords may kindly say, let my land fed say they issued the notification for appointment of judicial member. 21.9. After 6 months after passing of the order by the learned single judge, now they open their eyes and issue the notification. What I am submitting, Millard, it is squarely covered by several judgments of the apex court.
That's why we have agreed to hear it on 16th. Right.
6 months, Millard, is it necessary, Millard, to last me put irritatement yesterday?
No, so all we are saying is status quo. That doesn't harm you in any way. One. Learned ASGI submits. 1 minute. We are recording his submissions. This intra-court appeal arises from an order dated so and so, order dated. After vacation then.
Yes, brother.
That's a better idea.
Yes, brother.
Or maybe.
After Puja holidays, brother.
Yes. So it would be then Which date, Mr. You tell, both of you tell.
The first week, November, my lord.
First week of November, any Monday you prefer. 6th November?
Yes,
6th of November, my lord.
List on 6th of November 23.
But, if your lordship so pleases, my lord, 7th of November, my lord.
All right, 7th of November 20. Yes.
Decided two issues. Page 193. It's also held that 180 days are concerned.
Yes, that the order has, yes, this only for the purpose of admission.
There are other issues. Two other issues also.
You say inter alia held, no. In addition, the learned single judges further held that the provisional order of attachment cannot continue beyond the period of 180 days.
Pending, my lord.
Item
Number 17 in the same batch, but IA is pending
70?
my case with the batch.
17.
Yeah. But IA is pending, my lord.
What
to
IA?
delink my case with the batch.
What IA is pending?
To delink my case with the current batch.
No, there is no IA. This
IA
thing,
number 1 of 2023, my lord.
suspension, direction, early date. What is the same?
Direction petition, my lord. Direction petition to delink my case from the current batch.
Why?
Because they have not challenged the viruses of this act, my lord. And my main question is that the
Item 17. Yes. Who appears for respondents? What to say with regard to prayer for delinking?
But it can be delinked and had separately, but we are going to argue in before some other court.
All right. 17. Item 17. Party in person. That is the prayer. No, we are asking about prayer made in the petition.
But lordship may excuse my presence for that.
Yes.
Obliged.
Necessary to suspend. The same thing you have challenged. You have challenged the order passed by this thing. Authority under PMLA Act.
Yes, my lord.
So why it should not be heard? You will be heard. There is not a question of virus, Mr. You have challenged the order of adjudicating authority.
Yes, my lord. But there are several other grounds apart from the.
You will be heard. That doesn't mean that you will not be heard. Nothing. Yes. Yes, please.
Directed the issue of judgment has been clarified on the statute is constitutional validity of the statute is upheld. Whether substantive the same can be questioned. The pattern was so that's like it's not a secure law. Now the judgments are giving along in case for subsequent different from his case. Apex court has considered case for and clarified that facts and circumstances of the case where other parties question the vice of the statute. Courts can entertain this.
Which context?
That the lawsuit pass an order that
validity upheld, it cannot be challenged like on new grounds. It can be done now. Acha, we will see when it is. All right. Thank you. Yes. Thank you. Yes. No, nothing. It goes same order. Don't write anything. Yes.
In this case, senior counsel is suffering with fever. Last may kindly pick up this matter next Monday, my lord. Your lordship, so please.
So what is this is for early hearing date?
Yes, for hearing, my lord, I have.
What is hearing?
The rule is under challenge, but amendment of the rules.
Because this is 22 petition, Mr. No hurry.
Promotions are being taken.
No promotion. What is you tell us, Mr. What should there not be a scheme of priority? Like what 2005 appeals not, and these cases, so many of them have listed today for early hearing, just because you want promotion before Deepavali, so you want petition to be decided, order to be passed.
A new rule has been.
Let IA 1 of 2023 be listed for consideration in the month of January 24.
It's already interim order, my lord. Somebody filed implead petition, my lord. I need to file counter.
22.
I need to file counter, my lord.
Which
Implead petition is filed.
22.
22 and 24, my lord, go together.
22 and
24 go together.
You are petitioner.
I am petitioner.
For the petitioner, phrase fund is granted 2 weeks time to enable him to file. Yes. Mr. Your case will go before a special bench. Let this petition. This is SLP, right? 136. This order, if you don't like it. Yes.
Yesterday's Matt Miller, where the time was sought for.
Huh?
Yesterday's Matt Miller, where the time was sought for.
What happened, Mr. Pranav?
That's the interest of my colleague Miranda. My name is not effective. The interest of my colleague.
My apologies, Your Lordship. I've got the instructions, Your Lordships, in this matter. Our case has been considered and rejected, Your Lordships, because as per the Honorable Apex Court judgment, Your Lordships.
Relax. 2 minutes, then speak. Give us, madam.
The sponsorship has to be by the very near relative, Your Lordships, for getting seat in NRI quota. Whereas the sponsor of the applicant was far relative of that.
You file reply, madam, formally. Learned counsel for respondent submits that she shall file objections by
please, man.
No, 25. 25, what happened? Done, all right. All right, yes. Ah,
I have filed an
what, Mr.?
I filed an affidavit on behalf of the state, Lord. Selection committee, my lord, took a decision in the matter. So far as the district consumer members and president are concerned, a notification has been issued on 4/9. In respect of state commission, my lord, we filed a review for the Honorable Supreme Court. Speaking, the notification was issued prior to the orders passed by the Honorable Supreme Court, when the Honorable Supreme Court modified the appointment.
When have you filed review? What happened?
It is, I'm informed by the council.
Wait, madam, where is this? His counter.
Additional affidavit.
You keep counter with you.
Additional affidavit.
No, counter. Why do you keep it with you? This is needed, right? Yes. Yes.
My additional affidavits were not the.
Additional affidavit also. Yes. No, so first, what is your stand? You have filed a review petition.
Clarification petition before the Honorable Supreme Court, my lord. But the council is appearing in the Supreme Court and informed me, my lord, that mention has to be made before the Honorable Chief Justice of India. And he's heading a constitution bench, my lord. They are supposed to, I'm told, communicate through the email. But the date, my lord, probably will be granted for hearing the matter. Should be deferred for some time, my lord. All steps have been taken by the state. So far the district consumer forums are concerned.
You are seeking review of the order in SLP 831.
Yes, sir.
And 832. Yes, Mr.
I leave it on your lordship. A date may be fixed.
Leave it on. What else can you do?
Taking efforts, my lord, by filing.
Fine, yes.
A lordship may fix a date so that.
Learned special counsel. We can't. Learned special counsel submits that the. Yes, counter not filing.
Not filed.
Why?
Taken up. Taken up.
No, you don't want to file counter.
Request time. Request time. Because the departmental proceedings are.
Learned counsel for respondent praise fund is granted for. This is not an achievement of not filing counter.
Oh, proceedings were filed.
I didn't agree.
Yes.
Right, please, your lord.
What permission?
I'm instructed to appear in IN number 2.
What is permission?
We filed the USR number counter, we filed an application for opposing the withdrawal of the amount.
Lord, in the counter, with that appeal has become infructuous and they have liquidator admitted our claim to an extent of nearly 30 crores. Our claim is admitted by the liquidator, my lord, who is the respondent in this IA.
This IA you are seeking to withdraw the amount.
Withdrawal of the amount, my lord, that is already
Which is
deposited.
IA, madam?
IA number 2 of 2023. Let my friend finish, sorry. My lord, in the counter 11, they filed a counter, my lord. In the counter para 11, they admit that the appeal filed by the company corporate debtor has become infructuous in view of admission of my claim by the liquidator. However, they says if the appeal is infructuous, you cannot maintain this application in the appeal. In the, what happened, Malad, the facts are like this, Malad.
Yeah, appeal. Your appeal has become infructuous.
No, their appeal. Malad, there was an award in my favor, Malad. Against which they filed
where is IA, madam?
IA 3, IA 2.
2. That's what you should this listed for that IA. Yes.
Malad, there was an award, arbitration award in my favor. Against which, Malad, they filed application under section 34. Their application was dismissed. Again, they have approached this honorable court by way of under section 37, by way of present appeal, COMCA 3 of 2019. Now, Malad, in the meanwhile, the CIRP initiated against the appellant company and now it is went into liquidation. Malad, liquidator.
So they have deposited the amount.
Yes, Malad. Meanwhile, in 2019, garnishes have deposited. Now,
This,
Malad,
you 65 lakhs and 89 lakhs.
Yes,
20.
Yes, Malad. I am
Yes.
seeking withdrawal.
All right. What is
Now, Malad,
is it your case that appeal has become infructuous?
Because liquidator was appointed. Liquidator.
No. Appeal has become infructuous. Is it your?
I may just make this up. So what happened, Lordship will say, when the COMA 3 of 2019 was filed, there is an order, specific order passed by the court in IA number 1 of 2019. In that, an order was made, 1 crore to be withdrawn by the petitioners herein, and remaining to be withdrawn by the respondent who is an appellant before the court. A review petition was filed, review was dismissed, so holding that I'm entitled to get take back 63 lakhs and not. Meanwhile, the Bank of Maharashtra has initiated section 7 IPC code before the NCLT. Ultimately, a resolution person was appointed and the matter went into liquidation so far as that is concerned. And the liquidator was appointed.
Mr. There is an award in his favor by the arbitrator. That award has been upheld in a petition under by adjudicating a petition under section 37. Under interim orders of the court, you have deposited this amount. Why he should not be allowed to withdraw? Because he will run away with the money.
No, there is a specific order. Lordship, I mean, just Lordship, I look at IA number 1. Along the counter I filed, IA number 1 of 2019. There's an order passed by the court. IA 1 of 2019.
That he will not be permitted to withdraw the amount.
Yes. I am permitted to withdraw the amount. That is the order.
That
1 minute.
Yes, please.
This is the job of the council to create as much as confusion as possible.
Not confusion, clarity so far as that is concerned, sir. Not creating any confusion. That's borne out by the record.
Yes.
Lordship may just look at the order, sir.
19.
What? That is order dated.
Which case?
That is COMCA 3 of 2019, IA number 1 of 2019. 10th April 2019 is the order.
No, order. Which dated order dated?
The order dated, Lordship will get it at 10th April 2019. 10th April 2019. Interim order.
I filed along with memo yesterday, Malad, that order.
Along the counter of
10th April 21.
19. 10th April 19.
10th April. Yes, got it.
Just Lordship, please look at 6th para in the order, 2nd page. By the time, Lordship will just 6th para, page number 2. By the time the parties came up with these appeals, the execution petition was filed, and it appeared that the sum of which 2 crores 7 lakhs 29,987 was deposited to the 24 bill. As of now, being withdrawn by the first respondent herein. Therefore, even as per the award passed by the
last line. 63 lakhs you have been permitted to withdraw.
That is last paragraph.
The last paragraph. It is stated that the sum of which 1,63,58,000 is now lying to credit the court. This amount represents 25th bill. Question as to whether it is subject matter of arbitration is not becomes subject matter of dispute. Hence, we are of the view that allowing the parties to take the portion of the same would ensure that the first respondent would not receive 50% of the upper amount. Without producing the contention of the parties, the application for stay is disposed of, recording the fact that the first respondent has already withdrawn 2,07,29,987 paid towards 24th bill. Otherwise, the first respondent to withdraw 1 crore out of the amount now lying with the court deposit. The balance 63,58,000 may be withdrawn by the petitioner. So this is when the order becomes final.
Subject
And
of
the just a minute, sir. Review petition was filed, dismissed. Stating that this is the order passed by the court. Now you want
Review when it was filed.
review was filed just IA number, that is, Lordship will get it, IA number 2, sir, review petition. That is dated 5th September 2002, review orders.
Date?
Dated, sir, dated 5th September 2022.
5th September.
Yes, sir.
Yes.
This is the order, sir, review. May I read, sir?
Then that's enough. Review is rejected.
Yeah, that's what. Fine. Ultimately, it became final so far as that amount is concerned. Then once
63
again,
lakhs.
yes.
63 lakhs is fine. What about 25 lakhs?
25 lakhs is making additional claim now in the application. 50%, the court says that 50%, it works out to 50%. That's a usual conventional order that's been passed by the court. If he wants to withdraw the amount which we are entitled to, that comes within the judicial liquidator.
Fine.
I'll submit, my lord.
How do you explain these orders?
Yes, my lord, that's what I'm
19-4 and
Yes, my lord.
10-4 and this
Yes,
thing,
my lord.
review dismissed.
10-4 order, my lord, it was passed.
What is the amount is there till earning interest? What is it that why do you want to this thing?
My lord, I submit one.
You have been permitted to withdraw 1 crore
Yes, my lord.
only. 1 crore and 63 lakhs by respond number 1.
Yes, my lord.
By appellant, and you have been permitted to withdraw 1 crore. Why another amount in contravention of the orders passed by division bench? A review has also been dismissed.
That's what I
challenge. Go to Supreme Court then.
Your lordship may kindly see. Now, subsequent events, my lord, what happened? He has filed the appeal challenging the award. Now, my lord, he went into liquidation, liquidator appointed, and liquidator invited claims under section 30 of the IBC Act. But I filed my claim, which includes this awarded amount also. He admitted my claim for 30 crores. My lord, nothing will remain in the appeal to be adjudicated now. This appeal is filed against the award.
So we will dismiss the appeal as infructuous.
Yes, my lord.
Correct.
He admits that appeal has become
The other matters also have to be dismissed. All the matters they go, sir. But we put all the other matters, I think
that's what his submission is, that if it is infructuous, then you can't.
One thing. Ultimately, what will happen? Lots is aware of the first 65 of the.
No, we are not applying our mind. You have said in para 11 of your counter appeal has been rendered.
That's the reason, because it comes up.
That's the order which we are.
Once the liquidation process has come in.
Para 11, right?
Yes, but they do not survive. Actually, lots of.
Yes, then that's it, Mr. There's no. Our time is precious.
No, that's fine. I do understand, sir. I do respect the time.
Yes. RP presents learned counsel for the appellant while inviting the attention of this court to averment remaining cases?
Remaining, I don't, I was inspected.
Remaining cases, my lord,
29, 30,
Yes, madam.
31.
No, I'm not inspected. I only 3 I was inspected to appear. That's the reason.
What about 29?
Yes, my lord. In the remaining, that formal application to implead liquidator is to be filed. Lordship may have it of 2 weeks, my lord. I'll file a application to implead the liquidator. Now, in respect of
So
the,
this appeal survives? These
no, nothing will survive.
Nothing will survive.
Nothing will survive, but the formal application to be
So
filed.
we will dismiss it, Mr. Why to keep it pending?
No,
To impede nothing.
no, our appeals, there are two, our appeals, my lord, they have.
Tell us one by one, Mr. Item 29, does it survive? Be fair, Mr. Don't like,
Yes, my lord.
because we have not this thing, connected matters, we have not read it, don't
Yes, my lord.
this thing seek an adjournment.
Item
Be
15
fair to the court.
Item 29 does not survive, my lord.
Learned senior counsel for the petitioner submits that on account of efflux of time,
Thirty-two also does not survive, my lord.
does not survive, same order. Then 33,
33 also does not survive.
same order. 34,
Yes, but 34 and 35, that appeals filed by me, my lord, for enhancement of the award. It is not survived. Since he has admitted my claim, that may be recorded and closed. Since the liquidator has admitted my claim, so my appeals, since he has already admitted liability by the corporate debtor.
there we will hear, not like this.
Yes, madam. After
Let
2 weeks.
this item number 30, 34, 35 be listed after 2 weeks. Right.
Yes.
Yes. Next.
Obliged.
36. What early hearing? Who has filed?
Respondent number 1 in
Who has filed?
Not myself, I filed. I
What
filed
is
two
the-
applications, for one to implead,
Heard on IA.
another on expedite.
Implead. Who?
Implead, the implead party petitioner, he is the agreement holder. In fact,
So this is pending since 2014. What were you doing in pleading and all this?
an agreement was executed on 3/1/22 last year. Then immediately we filed.
We will
the
see
application.
that. We will allow heard on IA 2 of 2022.
I'm appealing for
Taking into
appeal.
account the fact that the appeal is pending before this court since 2014 IA is thirty-seven same order, 1st November. 1st November 23. Final hearing. Yes.
First November.
Yes. 1st November. Yes.
Meanwhile, let them die.
2038.
Hello. Lordship, in 37, direct them to serve copies to us, Lordship, respondent number. In 37, item number 37. They are not served copies to us.
How are you appearing then?
Respondent, Lordship, the matter is listed today, but in implead petition, they did not serve copies to us.
No, this is being heard finally, not interim application. Right? 1st November. 38.
My case, my lord, I beg to appear for the counsel, on behalf of the counsel for the petitioner, my lord.
That's all fine. What is early hearing?
Hearing, my lords, the petitioner is bound to retire in June of 2024, my lords, and pleadings in the matter are all complete. I kindly have it.
What happens if he retires? Nothing happens. With 2005 appeals we are hearing, Mr. Let IA be list. Let IA 1 of 23 be listed for consideration in the month of January 24. By that time, hopefully, some backlog will be cleared, then perhaps we can.
For non-prosecution.
What to do then? You don't appear.
But I was there on online, but my matter was passed over in the morning. But it was
Passed over in the morning. Why?
But,
Because we did not have time.
No, but counsel for respondents sought a passed over. I was there online. Then I thought the matter would come up after lunch. But it was called before lunch and.
That is the moment. We don't wait till lunch and all this.
Yes, I agree.
What is it?
Totally my mistake.
No, what is this thing?
Matter is securitization.
Interim order obtained and surviving on interim order, right?
Not like it is listed after a long time. I am ready with the merits also. It's a securitization matter against DRT.
Securitization, then appeal under section 7.
It is against a DRT order. It's against a DRT order. DRT passed.
You are into DRT and DRT.
Yes, after
both, there is no alternative remedy, right?
SA1.
No alternative remedy.
DRT order, I am challenging here. That's recovery applied tribunal order.
So say so, no alternative remedy. Why is it so difficult?
Yes.
We are asking you a simple question. Right? You should say so that there is no alternative remedy.
I didn't understand the question. Oh, sorry.
But you understand, right?
Now I
Satyavati Tandon, you understand Satyavati
Yes,
Tandon.
Lord, Satyavati Tandon.
In that context, we are asking you. So you should simply say no alternative remedy.
Yes.
For the reasons assigned in IA 1 of 2023. Next. Yes. 3.8 we have said that to list it in due course. Again it comes up. Magic.
I made a mention before.
Magic, right?
I made a mention.
Yes. What is it?
Milord, I beg to appear. I beg to appear on behalf of including.
No. Mr. 3.823 we have said that list in due course. How it has come today? Court slip. Why? Who has taken court slip? This is abuse of process, Mr.
No, Milord, I have mentioned it, and that day I was
mentioned it. What this is?
I was told that it was.
No, Mr. See this pleadings. The petition has been admitted. There is an order directing to list in due course. How it has come up, and now you are disowning the responsibility. I don't know how it has come up. Then we will conduct an inquiry how it has come up and will proceed. If it is found that it is at your instance, it is listed.
I will not do such things, Milord.
You will not. No, very good. Very happy.
I made a mention before you, Milord. It has been listed.
No, this 1 minute. Give it to him. Who has given this?
He has mentioned.
It is. This is on a mention memo, Mr. By you. Then you are saying that I don't know how it is listed.
I made a mention. On that day, I was informed it was on 5th.
No. Who has filed this? Then to say so that yes, sir, I had this thing. I had moved the mention memo. You are saying I don't know.
No. I have made a mention.
This is on a mention memo listed. We have admitted the petition on 3/8/23 and have directed this listing in due course. What is now early hearing? What is?
I have made a.
No, you are petitioner.
My petitioners are from number including petitioners. I'm representing.
No, not including petitioner, Mr.
Okay.
This is who appears for petitioner.
I'm representing Rahul Reddy. We are counsel for petitioner.
There's somebody has filed an incomplete petition in your case.
I have filed.
Why?
Because we are the affected parties.
How?
We are the eligible candidates for the promotion plan, which was the.
This has been admitted. It will be heard. What is there to include?
You know, the majority of.
I make one submission. While admitting and posting it to be listed in the usual course, when he mentioned that my implead petition is pending, your lordships have said that will be decided at the time of hearing. Your lordships,
We didn't say that, unfortunately. That's why he got it.
orally your lordships have observed.
That's we relied on that all counsels appearing or officers of the court. We should have been very specific. We didn't know that he will take advantage of that
No, but the
situation.
proceeding sheet also reads that pending IA shall be considered at the time of hearing of the petition.
Then all this thing pending IS, which order sheet?
Yes. 13th September.
In view of order dated 13/9/2023, directing that pending interlocutory application shall be considered at the time of final hearing. No orders are required to be passed on IA 1 of 23, 2 of 23, 2 of 23, 2 of 22 and 1 of 22 at this point of time. Yes, what is early hearing? Who has filed? Since the impleading petitioner has filed an IA for early hearing which is yet to be allowed, let the application itself be listed in due course. Yes.
I'm obliged.
Next. What is this?
May please.
Who has filed?
May please your lordship, my lord. This is
You have filed an application for early hearing.
not early hearing, my lord. I filed an application, my lord, for implead application I filed because I am an affected.
You want to file objections? File, do so. Learn it. No, objections to implead petition you don't want.
And one more thing also.
No objection.
And also.
Fine.
One more.
Third on IA number 1 minute, madam. Implead petition means he has no objection and then the cost title has to be this thing. Third on IA 3 of 2023 and IA number 11 of 2020, 11 of 23, 2030. You have said I have no objection. You carry out. We will consider.
I filed my IA 10.
IA 10 will be considered after 1 week.
It's an date. IA 2 are filing complete. I filed that IA.
So it will be, everything cannot be heard, mister, because you want it to be heard. Please tell us, what is the sin committed by a litigant who has approached this court in 2005 and is waiting? What is the sin? No sin. We don't want to argue. Yes, go ahead. No, after 1 week. 1 week. It will come up. This order again is open to challenge if it's not to your liking. Yes. Next.
The last time I post for hearing that my IA may be allowed.
No. You have said that you don't have any objection to implement it. So you carry out the amendment first.
They will carry out.
Whatever, whosoever. I don't know. It's your petition. If according to rules here, they will carry out. They will carry out.
I only request is.
No request.
Here, they are finally.
We will decide a date when your application comes up for hearing. Today we have allowed the impleadment. Yes. We have allowed the impleadment today. We will not. We have said that IA will be considered remaining IAs after 1 week. This is the order. Yes. No. After 1 week we have said. Yes. Next.
Without date, the office not posting.
No. It will be, you know how to get the cases listed. You come out with 5 court slips. We have seen.
Again, I can't make it.
Ask your junior colleague to do it. It's not at your age, you should not do everything. Ask him who's assisting you to do something. He will learn. It's your duty to bring him up as a good counsel. We are conscious about that fact. That's why, please, next. No. Yes, counter.
I'm okay, but first and second. I request you not very grand for this time.
Learned counsel for respondents, praise warrant.
I filed 6 months back. But last time I take, after that case is admitted. The case is.
What you are opposing? You don't want him to file the counter. Time should not be granted.
I am seeking interim order. How many times you are kindly see? The state allowing one officer.
There's no need to shout.
No, not shout. Please, you are
Switch off.
Watch out, sir.
All right. Yes. You are arguing the case on interim relief, right? Yes. That we will decide. So it is item 42. Yes. What direction? What direction? Post the petitioner in a place of your choice. Right. Place by accommodating them as superintendent so and so. Yes. What ground basis this direction can be issued? This is only for interim relief, Mr. Don't argue for. We will not give you half an hour. Conclude in 5 minutes. Petitioner is?
By working at that and it has been luxury promoted and that's not a of the guidance of the after promotion, if the obligation on the part of state and then counseling and that issue posting us. These are the senior number 3. It's the most the century. The entire state there are
Senior most.
and
So what he is not been given posting?
what happened is conduct counseling or okay. You participated counseling.
For posting. So they are not doing it.
From those there they wanted.
We have got you understood. Yes. Mr. Has he been promoted to the post of additional director?
27/12/2021, he has been
Promoted. Then he has to be given posting. 1 minute. He has to be given posting as such, being he has been promoted as additional director.
Yes, been done.
Done?
Yes.
When?
Page 79. Superintendent, Government General Hospital, 140.
Superintendent?
He has been given. This is an order issued in the year 2021.
Which page?
Page 79.
79. Yes.
GORG number 698 dated 7/12/2021. Lord, in the table, TSHC number 3.
Yes.
Right side, Lord, Superintendent, Government General Hospital.
Yes, Mr. Now, what is your grievance? What interim relief? You have already been posted and serving.
Posting should be based on the Milad counseling. Third, they conducted counseling. I can see Milad counseling.
So your submission is without counseling. So therefore, you should be posted at Government General Hospital, Vanapanthi. This is the prayer.
conducting, it's supposed to be properly.
Ah.
Subject is not there. They are not slating my services.
All right. Yes. All right. Fine.
Can we take from page number 89? Page number 89.
That's what we are understood, right? 89. Well, their services, your services are not being utilized, but you are being paid salary, right? Happy? Yes.
89.
Yes.
Government issued on following. The apartment for now.
Yes. So this order has to be quashed, right, to get you the relief 7/12/21 by way of an ad interim order. Then, or if this order is quashed, then only you will be entitled to posting somewhere else. All right. Understood. Anything else?
What happened?
Will be subject to the that we will record. They have to find out. Yes. All right. Yes. All right.
Second candidate. Government goes to the charge director medical education. Based on recommendation, that persons like not me, both respondents have two the likes. Those things not places not city. And not I should have given not charge director. Thinking that not right the course. He will not influence the government to post not parliamentary. Where will not pedagogic subject is not well. In this day, only two not themselves. Posting will not pedagogic subject. One is both respondent, second is mine. Second, both respondent. For the sake of paper, he is going to post of principal, not the medical college. But he is doing administrative work as director of medical education from 2017, but doing so much better. That go on to our should see that they are not clear about all this. Now we are this is the case. Now this case is noticed for admission of knowledge. No count is paid. In Hyderabad, all the response. After 2 lakhs were admitted and issue notice, no notice. Even then they did not find out that even for individual. That is not identical, deprived, but my rights, not anything. And now,
Learned senior. That's it. Learned.
and now the respondent also did not appear. Submitted on one weekend. Post learned small.
Learned. It will be the young man that we are concerned about his future. No, not difficult. Not difficult. Not difficult. We grant. No. We are granting every mentioning, Mister. You should be here in the morning. You know, all your mentioning has been granted. We don't. This thing. You don't come. This young man is with you. The person. Let him. You send him. We will deal with him. No, don't come. We don't want to trouble you. No, nothing. No, there's no first, second vote. This, let him come. We want youngsters to argue. Let it, you send him. We mention. We'll do it. Yes.
May I please?
Yes.
Lord, application is filed, my lord, seeking appointment of arbitrator. My lord, notices were served, my lord, no counter is filed. And your lordship may see, my lord, another.
Counter is filed.
No. I seek time, 2 weeks time.
No, nothing. No weeks. 2013 matter, Mister. This is a joke. Supreme Court has deprecated. If the arbitration, I was shocked to know these matters have been listed. We found out that there some arbitration matters are pending. What is this? It's not like it's worse than a civil suit. In civil suit, by now, at least evidence would have been, it would have been at the evidence of at the stage of evidence. We are sorry. Nothing.
In fact,
no.
It is covered by constitutional bench of the Millard Supreme Court. The agreement is not Millard properly stamped.
That's it. Then it goes, Mister. You know that.
No, my lord, what happens?
No, nothing happens.
CRP 44.
Madam, judgment, Constitution bench judgment. 2023, volume 7.
My lord, sir, kindly.
1 minute. We are not doing anything, Mister. You are not assisting us. We are trying to find out.
No,
because we have to write an order, right? We do the homework for you, right? No, we do the homework for you. And still, if you have guts to argue contrary to Constitution bench, God alone can help you. See, this agreement is not properly stamped.
Well, that is how CRP 4181 of 2014 before your lordship, item number 44 is before your lordship.
First, item number 44, give.
Before your lordship.
Give item 44.
My lord, what happened in this case, my lord? I filed an application.
1 minute. 1 minute, please.
43, 44, 45 are one and the same, arising out of the same.
43, no. 43, 44, 45 are not same. 43 is arbitration application, 44 is CRP, 45 is CMA. Not same.
Section 9 application CMA, my lord, as against Section 9 application. My lord, this
application has been rejected on the ground that the agreement is insufficiently stamped.
Yes. Now, your lordship,
what is wrong?
Yes. My lord, I will take your lordship to agreement at page in CRP, my lord.
No, Mister. First, you should tell us what is your contention that it is properly stamped.
Yes,
it is properly stamped. That is so. They say so.
Yes, it is properly.
Taking doesn't mean.
Sorry.
So then
it is a properly stamped on
Mister. Fact is that it should be properly stamped is a law conclusively laid down by Constitution bench of Supreme Court, which is binding. If you don't feel like it is still binding, right, on you, you may not feel.
I'm not.
But so this proposition that the law laid down by Supreme Court that an arbitration agreement has to be properly stamped, that binds everyone. Now you tell us how it is, what is the requisite stamp duty, what is the document, what is the requisite stamp duty, how much it has been paid. Simple.
Yes. My lord, under Article 6C, my lord.
No. What is the agreement?
Agreement is at page 33. Agreement, my lord, the applicant is a construction worker, engineer. He entered with a contract, my lord, with the respondent.
33 is no 33. There is no agreement at 33. Agreement is page 27. Agreement for construction of building.
Yes.
Yes.
My lord, may I read? This agreement made and executed on so and so. Mohammed Shafiq is the owner of the property, my lord, and I am respondent, my lord, Mrs. M.R. Constructions is the person. Whereas the engineers contractors is desirous of carrying out civil works for the proposed residential building at survey number so and so, whereas engineers contractors has approached the owner, expressed his willingness to carry out construction work as desired by the owner. Whereas the engineers contractors has assured the owner that they have necessary experience, technical skill, manpower, material infrastructure to carry out and complete the works as desired by the owner. Whereas the owner accepted the experience of the civil works of the engineer contractors and decided to entrust the construction works to Mr. M.R. Constructions, who shall be engineers or contractors for the above said residential building of having ground floor plus 3, but constructions 3 plus 2 floors, only total 9 flats plus 1 watchman room plus 1 shop, whereas the approximate slab area for the execution shall be as per plans. Whereas the engineer contractors has agreed to complete the above said construction within 365 days from the date of contract agreement as per drawing, as per the terms and conditions and specifications mentioned below, Annexes 2 and 3. A copy of the agreement kept at site and may be referred to whenever necessary. Terms and conditions for construction of building. The contractor work will be started within 8 days from the execution of agreement form. The construction of building will be completed within 365 days, depending on the site condition and availability of material and manpower. If any delay is caused only due to unforeseen reasons, such as unfavorable climatic conditions, strikes and bunds, etc., all the required tools and plants, machinery and employment and building walls, baskets, spades and crowbars, scaffolding with rope shall be arranged by the engineers contractors. Well, these are all the terms and conditions for raising the building, by the engineers. No interest is there in the entire reading of the agreement. The owner has he took only contract, my lord, for constructing the building in the land of the owner.
So it is under 6B of the Stamp Act.
According to my lord, the code below, it is 6B under the contract. Stamp Act section
6B.
Schedule 1
6B.
6B of the. My contention is, my lord, it will be under 6C because it's only a civil works contract, it's not a development agreement. There is no interest is given to me. I am not.
Agreement relating to construction of a house or building, including a multi-house or building, so and so.
Yes. Then the subsequent clause which is there, that is, your lordship will see.
This is an agreement relating to construction of a building, right?
Construction of a building by an engineer, not for development, not for sale. He has not taken anything for sale of that building.
No, it doesn't say for sale.
Last paragraph, your lordship will see.
No, it is by an engineer or by a chartered accountant, by a doctor. That doesn't determine.
Lordship, right, my lord, it doesn't say so.
So it doesn't say also that if it is only for by a doctor and for sale by an engineer and not for sale, therefore 6B will not apply. It's not like this. The decisive words are relating to construction of a house or building. This thing, admittedly, Mr. One thing we must understand. If it falls under section 6B, it is not your case that it is stamped as per 6B. Your case is it is under 6A. 6A.
6C.
6C. So 100 rupees.
100.
All.
Now, my lords, make a division.
So how it is 6C?
My lords will see. The 6B reads, my lord. May I read 6B, my lord?
In relating to?
If relating to construction of a house or building, including a multi-unit house or building or unit of apartment, flat, portion of a multi-story building or for development, sale of any other immovable property. This sale of any other immovable property was considered by our division bench and it was held, my lord.
Or for. It's not and. Please understand or.
Or sale of any
other. Or for development sale. This is an.
Development or sale of any other property.
Not and.
Yes.
Both the conditions should not coexist.
Yes. Now, yes. Now, my lord, what happened in this case, my lord? The 6B, there is a adjustment, my lord, given in what say Article 47. Lordship, may kindly see Article 47A of Schedule 1A. My lord, this Article 47A says, suppose I pay any stamp duty under section Article 6B, then it will be adjusted. If
The court is not concerned with this thing. Court is only required to find out whether it is properly stamped.
Yes, only to
Under
that extent.
section 33 of the Stamp Act, any document not properly stamped has to be impounded. Simple. I mean, an adjustment. What you find out with adjustment, what is with him.
No, the proviso, my lord, to explanation to Article 47 says, provided that where subsequently a sale deed is executed in pursuance of an agreement of sale as aforesaid or in pursuance of an agreement referred to in Class B of Article 6, the stamp duty, if any, already paid or recovered on the agreement of sale, the adjusted towards the total duty leviable on the sale deed. My lord, this I will never get. I am only a contractor. I only executed the work. I have no interest or right in the entire construction. I must only get the value for the services which I have provided to him. Therefore, it is neither agreement of sale nor agreement of any right in the property.
Is it not an agreement relating to construction of a house?
I am only a mason.
Then also, the value is above 100 rupees. No, it doesn't say, see the agreement or memorandum of agreement provide in relation to construction of a house or building, including a multi-storied or building or unit of apartment, flat portion, so and so, or element of sale. No, or. So if an agreement is in relation to construction of a house or building, or for development of sale of any other immovable property. This it is the agreement may be for development sale of immovable property. The agreement is not getting any to sell. What I'm saying is that even if it's an agreement relating to construction of a house or building, including so and so buildings, this is. So we have to read up together. Or is this agreement may be to unit of apartment, flat, portion of multi-story building, then for development sale of so and so. It's not and. We can't read independently. We can't read the and. All right, we have understood your submission.
My lord,
Fine.
this judgment, this, my lord, we underwent an interpretation by our High Court and Division Bench.
Yes, that's important. So it has been read what, how, and.
And your lordship will see, my lord.
And. Yes.
My lord, because otherwise, my lord, a engineer cannot have any right over the property and adjustment will not be able to do under 47.
No, the engineer means it's not that we are against engineers or something like this. So the only thing is whether he can invoke the arbitration. I mean, if he doesn't invoke, then he has the remedy to file a civil suit. Yes.
To articles, I'll take your lordship, my lord, to direct me to paragraph 19.
19.
Yes. Article 6B is very clear in its expression.
1 minute.
I'm sorry.
This is different. The question was whether it includes agricultural land also.
That was the question, my lord. Thereafter, my lord, at para 16, my lord, para 19, my lords may kindly.
We are seeing para 19 only.
Then, my lord, on the right hand side column, my lord, a careful reading of.
This is this is amended. This agreement does not contain agricultural land, does not cover agricultural land. This is the ratio.
That was the ratio, my lord, while interpreting that the adjustive generis clause need not be looked into, specified words only has to be looked into, and what follows is sale of any other immovable property My lord, only for the purpose of construction, my lord, a construction contract, it's a civil works contract given to the contractor, and it is not a development agreement. It is not a development agreement that he has got any right in the property.
No,
And thereby,
why we see, Mister, we are dealing with the expressions provided for by the legislature. It does not say development agreement. It says agreement or memorandum of an agreement in relation to construction of a house or building, including a multi-unit house or a building, or unit of apartment flat, portion of multi-storage so and so, or for development and sale, an agreement or memorandum of an agreement for development sale of any other immovable property. So this is it is first part is agreement in relation to construction of house, agreement in relation to development and sale of any other immovable property. This is how it is in two parts. So this is, I mean, we don't think that it helps you in any way, like 2004 division bench.
My lord, your lordship may kindly bear with me for a moment, my lord. Article 47A.
This adjustment we are not concerned. We are trying to understand the nature of document, Mr.
Yes.
If you have anything to say in respect of interpretation of this article, then it's all right. This adjustment appropriate to you, file against him, do whatever.
No,
that stamp duty, I have to recover this much of amount. I have constructed his house. He is not making payment of amount. Do whatever.
My humble submission, my lord.
This is what it says. It's this thing. See, it is in two parts. Simple, right? Agreement on construction of building, house, so and so, unit, apartment, so and so. Number two is for development sale, an agreement or memorandum of agreement for development and sale of any other immovable property.